and in areas where the individuals are subject to our jurisdiction. And we understand that the Human Rights Committee interprets the and as an or, but we think that is not consistent with the negotiating history of the treaty. And while one can imagine that some international critics might suggest that Boumediene should prompt a change in the view of Guantanamo as part of the territorial United States, it is clear from the opinion that the court clearly considered Guantanamo, while we may have de facto sovereignty, to, as a legal matter, not be part of the territorial United States. So I think we're on sound ground in saying the human rights treaties don't apply to Guantanamo. So if that's the case, well, what about, does the decision tell us the Supreme Court thinks the war is now over? Is that maybe what is going on here? The court's had enough, war's over. But I also don't think that is an accurate description of the situation here. The Supreme Court has affirmed in the Hamdi and Hamdan decisions that the legal framework for this conflict is the law of war. And it was taken as a given in Boumediene, and as an issue the court spent quite a bit of time with, was whether or not it was appropriate to apply habeas corpus to alleged alien enemy combatants. So how then are we to understand the court's decision in international law terms? I think the legal advisor's speech that he gave in Oxford last December is maybe a good signpost on how to look at this situation. He noted that it was an open question within international humanitarian law as to what process an individual is entitled to in determining whether or not he's a combatant. I mean, if you think about traditional armed conflicts, you would not be surprised to learn there aren't a lot of rules on this, because in a traditional armed conflict, you're looking across the battlefield, seeing someone else in a uniform shooting at you. It's not surprising. They don't need rules to decide who's a combatant. It's pretty obvious. But in a conflict like this, it's not obvious. And you look at the non-international armed conflict provisions like Common Article 3 or Additional Protocol 2 to the Geneva Conventions, and you similarly see that this has not been addressed. And we ourselves recognize this difficulty, and we tried to remedy it through the CSRT process, the Combatant Status Review Tribunals, that initially determined whether or not someone was or wasn't a combatant, followed with review in the federal courts under the Detainee Treatment Act, prompted, of course, by the Supreme Court decision in Hamdi. We now know that was insufficient. As the legal advisor also explained in Oxford, human rights law is often suggested as a gap filler where international humanitarian law is considered inadequate. And while I think that is an okay suggestion, I think the difficulty is considering whether any particular piece of human rights law should or shouldn't apply in a particular situation. Does it apply as a treaty law matter? Is it customary international law? Or if it's neither of those things, is the argument just that human rights law provides an interesting policy suggestion for how we should move forward? And I think if you look at it in those terms, what the court has really done here is it, in the course of interpreting the Constitution, has in fact used a human rights concept of habeas corpus to fill in a gap that existed in IHL with respect to what process a detainee is entitled to for combatant determination. So what's motivating the court? Well, probably some of the things that John talked about, and in addition that are noted in the opinion. For example, the detention facility is away from the battlefield and is in an area of total U.S. control. Many of those, or at least some of the individuals that were picked up weren't picked up in traditional battlefield locations and may not have been engaging in hot battlefield activity. And of course, the length of time that's involved in the detention. So is that it? Is that a good outcome? Is this where we want to be? Is it human rights law the answer for addressing this difficult problem in IHL? Well, I think I want to at least point out two dangers that I think this decision poses. The first of which John addressed briefly, which is the idea that these protections would move outside of Guantanamo. Certainly, it's one thing to have courts and lawyers and habeas corpus at a location like Guantanamo, which is far removed from the battlefield, where people have been detained for a long period of time. It's still another thing to have it in hot battlefield areas like Iraq and Afghanistan, where the courts would be interfering with active wartime decisions and would make it difficult for commanders to succeed in the war on the ground. Luckily, as John pointed out, it seems unlikely that the court would feel comfortable in going in that direction. And I think if you look at the opinion, a lot of what was motivating the court, or some of what was motivating the court, was a concern in distinguishing the Iraq and Afghanistan context. And I think the second point is that in increasing process, you end up decreasing the incentive of the executive to hold detainees. Now, if John's hand-raising exercise is correct, I bet many of you think that's great. It's wonderful. We should discourage the executive branch from holding detainees. But I at least want to point out 3 negative repercussions that you may or may not have thought of. One is that people we let go may commit terrorist acts later. And this is not a hypothetical threat. For example, we released a Kuwaiti detainee, Al-Ajmi, 2 years ago. He was supposed to go to Kuwait. The government of Kuwait was supposed to manage the threat that he posed. Nevertheless, he escaped from Kuwait, found his way to Iraq, and conducted a suicide bombing in Mosul that killed many innocent Iraqi civilians. And there is a danger, of course, that the more people we let go, we're going to end up in that situation. Second, there is the concern that we're going to be forced to sublet detention operations to third countries that have less humane treatment protections than we do. For example, the international force in Afghanistan has adopted a 96-hour rule, which says that they will hold detainees for 96 hours before either letting them go or transferring them to the Afghan government. And they're motivated by this rule, at least in part, by concerns about what their local courts are going to decide on these kinds of issues. And lastly, one of the fundamental bedrock principles of law of war is proportionality and necessity in actions. And we must be concerned about rulings that would cause individuals to want to be more aggressive on the battlefield to avoid conducting detention operations. I think this is a legitimate concern, not to suggest that one would act outside the law of war, but if the greater the process that's associated with detention, the greater the difficulties for the government in conducting detention, the more difficult these questions become. So I've already spoken over my time. I just want, quickly note on transfer litigation. I think many in this room would probably agree the president was right when he says we'd like to move towards the day when we can close Guantanamo. But one of the greatest difficulties that we've faced in closing Guantanamo is the problem of what to do with individuals who come from countries with poor human rights records, because these countries cannot or will not provide reliable assurances about how these people will be treated. And I think the question that people are asking after this opinion is, are we going to see a spate of litigation in the federal courts on the question of whether or not transfer is or isn't appropriate? You can imagine, I think it's probably not the greatest idea in terms of moving towards an expeditious drawing down of the population in Guantanamo for there to be a lot of litigation. I think the happy news is that the Munaf and Omar opinions, which were decided on the same day as Boumediene, suggest that the court, at least in the first instance, thinks it is appropriately left to the political branches to decide who is and who is not a combatant. What the scope of that decision is and how it will apply in Guantanamo is unclear, but it's something that will be interesting to follow. And I'm happy to talk more about that issue if you have questions. Thank you.
As Nancy said, I started out my career working with the Center for Constitutional Rights, which brought the first Guantanamo cases. And when they brought the first Guantanamo cases, they called me and asked me if I'd work on them, and I declined for a number of reasons. One is I wanted to have a life, something that some of you might recognize, a desire that's often put into conflict by taking on certain kinds of obligations, and I've seen many people lose their lives to Guantanamo litigation. But secondly, I thought it was a hopeless case. So everything that I say from now on you should treat as highly suspect, given my assessment of the Guantanamo case. In some sense, I think Boumediene was a limited decision, and certainly to the detainees, it will be viewed as a limited decision. After all, it's only about whether they get in the courthouse door. It's only about that threshold question. It's not, doesn't actually decide, as John pointed out, any of the questions on the merits that will subsequently be determined. No one as yet has been released from